joined. Hello and welcome to the Elevating Your Medical Practice webinar hosted by Santa Clara County Medical Association. Thank you for joining us today. We're excited to be able to host all of you. We're pleased to bring this program to physicians and office managers from all sorts of different medical practices to assist with operations and to help your office succeed. Today's webinar is made possible in part through the support of the Cooperative American Physicians, or CAP. CAP is a leading provider of medical malpractice coverage in California and services nearly 13,000 independent physicians. Their coverage options and benefits are tailored to address today's healthcare related challenges and help physicians manage successful practices. The next Elevating Your Medical Practice webinar will be Wednesday, and it'll be next month on Thursday, April 24th. And that will be that will be along the lines of working with the current federal landscape and all of the changes. You can watch all of the recordings of all webinars by visiting our website at sccma.org under programs. And today we have Mr. Russell here, Mr. Russell Ryan, who will get started with the webinar. Thank you for joining us.
Thank you. Well, good afternoon, everybody. It's a pleasure to be with you today. I'm going to spend some time talking about the employment and healthcare related regulatory and legal changes for 2025. I know we're a couple of months into the new year, which seems like it's going really fast. But this is something that I've encourage every year that you make sure that you at least spend some time learning about the new updates. California is never content to keep anything the same. It always makes it tougher on employers, and in the healthcare setting, which is where I spend most of my time as an employment law and healthcare related attorney, it just seems to be more expansive every year. Just by way of background, I practice in Central California, the Fresno area, although I have a practice up and down the state. I am a local Bay Area guy, having gone to elementary school in Hayward, and also went to law school at UC Berkeley, and started practicing in San Francisco back in the late 80s. So I'm getting pretty old as time goes on here. Have clients in Alameda County, Santa Clara County. I have cases in Santa Clara County right now that are employment related and typically represent employers, although I will help an occasional employee. So I have a handout that hopefully is a bit accessible to you, which I'm going to go through and talk about the changes here over the next hour or so. I'll get you out, a few minutes early. We'll leave some for additional questions. So by 12:10 or so, I will make sure that I'm finished up. So I'm going to go ahead and share my screen, and we'll bring up the handout for today. Make sure I get it here, and there we go. So you should be able to see it. It says Santa Clara County Medical Association at the top. So this past year, as has been the last 2 or 3 years, significant changes in the employment wage and hour law and other employment regulations. And as I mentioned, my focus really is with healthcare. Probably 70% of my clients are healthcare related. In some form or another. I represent the larger federally qualified health centers in Valley and parts in Southern California as well in Northern California. Represent doctors' offices, ophthalmology practices, dermatology practices, some dental groups as well, small rural hospitals as well as larger groups. So I'm going to try to cover the whole range of providers and how it might apply to you to make sure that nobody feels left out. California has worked very hard to make it as challenging as possible for healthcare employers to move forward. But now with the new, ever-changing, unknowing changes that were going to happen at the federal level, that's going to be just another layer of challenges we're going to have to deal with. Let me first begin, and you probably are all quite familiar with this already, but just a confirmation. Minimum wage increases for 2025. Just the non-healthcare related minimums are 16.50 an hour. By county, you may have slightly higher, and especially if you're more in San Francisco and other areas, you might have a little bump on that as well. But 16.50 an hour is the minimum. What that means for salaried positions, exempt positions, which will have duties associated with those as well, but the minimum compensation requirement for non-doctor exempt employees has risen substantially, almost 50% the last 5 years, and is now the salary must be at least $68,640. For physicians to fall into the exempt category, you have a separate minimum wage rate, which goes up each year according to the Consumer Price Index. And that's this year, it's $103.75 an hour. Now, I get asked often, and I just had this question last week with one of my clients. Does that mean that as long as the annual total compensation is over the 103.75 an hour, which comes out to, like $215,000 or so a year, as long as they get that as a yearly basis, does that meet the minimum wage to have exemptions for physicians? And the answer is no, it doesn't. It really needs to be based on every pay period should show a minimum of 103.75 per hour. So if you're thinking that end of the year bonuses would help meet that exemption, technically they measure it by pay period each month, 2 times a month. So if you ever had an issue with the labor commissioner or other claim, they won't measure it by year, they'll measure it by pay period. So make sure that you show on each pay period. And maybe that means that you might have to prorate the bonuses during the course of the year. It might mean that you have to do some adjustments on what the salary and maybe you have, a bonus per visit. You want to make sure that those are not paid out every quarterly if you're close to that 103.75 an hour. So just a complicating factor. Want to make sure that you're aware of that because it is measured by pay period and it reflects by hour as opposed to over the course of the entire year. Now we do have the new healthcare minimum wages. They did get pushed back about 6 months last year because Governor Newsom uh, realized, discovered, wasn't sure of the fact that, guess what? State and healthcare workers were also required to comply with the minimum wage increases. So they put it back 6 months so they could exempt certain state positions from that. So didn't really get going in place until around October, but it is in place. Various on depending on what size facility you are and what size of your practice is, you may be exempt. So I'm just going to hit, or it might be delayed. But just as a brief summary, large healthcare employers like large hospitals, large systems, you had to start last June at $23 an hour. On July 1, you'll go up to $24 an hour, and next year you'll go up to 25. Safety net hospitals, which I represent a couple of those, the smaller urban, smaller rural type hospitals, you were able to stay at $18 an hour until this coming June 30th. You're supposed to go up 3.5% as of July 1, 2025. So keep that in mind. You get a break more than most because you have several years you do the 3.5% increases, so it's slightly lower than the minimum wage for others. Clinics, like my federally qualified health centers, other types of clinics, you had to go up to $21 an hour last October or so. And you have another year on that $21 an hour to June 30, 2026. You'll go up to $22 an hour on July 1, 2026, and then 25 after that, unless they adjust that, which we'll see what happens with the current economy and the uncertainty at the federal level and how Medi-Cal reimbursements look. That may very well get pushed back. And I think that we're probably hoping that it will. But keep in mind that that is what the current plan is, and there's no change as of yet. Skilled nursing facilities, I do represent a skilled nursing facility. Supposedly, they were supposed to go up to $21 an hour in another year. That only takes effect if certain patient care minimum spending requirements are passed, which has not happened yet. So you'll probably get a longer reprieve from that. We won't know for sure until we get closer next year, but keep in mind that you should be planning on that if and keep track of the legislation to see what happens. For other facilities not named that I haven't mentioned yet, most had to will go into $21 an hour as of June 30, 2026, which is next year, and then it'll bump up to 23 and then 25. What this also means is that the exempt salary number is going to change here for you in the next year or two. There's going to be the way it's going to be calculated is you look at the regular minimum wage exemption, that 68,640 I mentioned, which is essentially $16.50 times two. So you're talking $33 an hour. When the healthcare minimum wage gets up to 150%, or when that's going to be higher than $33 an hour. So let's say once you get up to right at 22 or $23 an hour, which you'll get to in the next year or two, most of you, then you look at what's 150% of that, which just means, 1.5 times, a time and a half of that. Once you're getting up to $23 an hour, it's going to be passing the California exempt wage. So you're going to have to do a calculation each year, look at the healthcare minimum wage, multiply it by 1.5, and once you get to $23 an hour, that number is 71,760 a year, 3,000 more than the current wage. So you could expect that in the next year or two, your minimum wage for exempt employees is going to be at that higher number based on the healthcare minimum wage. There are exceptions to the minimum wage obligations under California's healthcare minimum wage law. Free clinics, tribal clinics, I do represent a couple of tribal clinics. They're not subject to these rules, which is good for them, especially because their funding may be at risk with the changes at the federal level, at least some portion of those funding. Private medical practices under 25 doctors are exempted for now. That was what they needed to do to be able to get the medical board to support the change. We don't know how long that's going to last. With the uncertain federal landscape, it may last longer because, especially if you're heavily dependent on Medi-Cal, we may see something where if you have a certain percentage of your income comes from Medicare and Medi-Cal, you may, even if the larger groups may be exempted because of possible reductions at the federal level. So we'll keep an eye on that. But how much comfort is that to you? Because you're often competing with federally qualified health centers, for example, for your medical assistants, for your front office. So it may be, and you're in higher, the whole Santa Clara County is in very much a higher cost of living area. So whether or not you're exempted from the healthcare minimum wage, you may need to pay that wage just to stay competitive and to be able to get people to apply for jobs. So know that you will have direct competition with clinics, hospitals for those MA type positions. So you may be paying those numbers anyway. If you are small time practice, but you are otherwise subject to these healthcare minimums, there is a waiver process. You can go to the labor commissioner and show your financial condition and hope and pray they might give you a waiver for a period of time. They have an obligation to at least consider it, but there's no factors as to how they would consider it, what discretion they would use. I do not know anybody yet who's actually obtained a waiver from the healthcare minimum wage by going to the labor commissioner, but at least it's theoretically possible, just so that you know. If you have questions about that or you think you fall into that, my information's on the documents here. It's available to you. I'd be happy to chat with you about it free of charge, just to let you know what you think the options might be. All right, and as I mentioned, state employees are not subject to the healthcare minimum wage now unless you are part of the University of California system. Then you are, because that's doesn't the state didn't want to exempt anybody as that was not directly connected to them. We know that the system is funded by the state. I work with the UC San Francisco system in Fresno, the residency program. I'm at one of the non-doctor board members. We've had interesting discussions about this since it would seem like maybe we should get a little bit of a favor, given that all the other state employees are, but nevertheless, they did not exempt the UC system from that. All right, let me talk about other new rules in California for this year. As you may have known from last year, the California Fair Employment and Housing Act was changed so that employees could take off time, much like an FMLA type leave or a California Family Rights Act leave, to deal with conditions if they were a victim of violence. You think about domestic violence, but it was really kind of any type of violence, was workplace violence or other types of work violence. Most common would be a significant other, a partner, a spouse violence, but it was basically anybody who was a victim. This year, that has been further expanded so that if you have a family member who's a victim of violence, you have similar protections and the right to be able to take off time for leave, time, and also other obligations, which I'll talk about in just a moment. Now, there's the way this is divided up is those that have 25 or more employees are required to give the employees time off, not paid, but time off like you would under the FMLA or the California Family Rights Act, which basically means unpaid time off with job protection to care for their family member and themselves if they were victims of violence. Um, so that is for 25 or more. But those that are under 25, you still have to be able to provide time off for certain situations, not the 12 weeks, but certain incidents, which I'll describe now. Under the law, the term family member is pretty expansive. It includes children, parents, grandparents, siblings, spouse, domestic partner. Also, the way sick leave was changed in the last couple of years and leave for family members under the California Family Rights Act, they also added a category of designated person, meaning somebody who may not be related to you at all, but they're a special person in your life. You have a right to exercise these types of sick leave rights. In this case, leave rights for being a victim of violence. To anybody, basically. It could be a significant other that maybe you're not registered as a domestic partner. Could be somebody who raised you like they were your mom or your grandparent. It could be somebody who's just close to you, and you have to designate that person to your employer that they're special in your life. You don't have to explain how detailed that is, but you can only change it once a year. So you can't have a best friend you want to take time off for in February and then change it to a new best friend in March. It's only a once every 12-month type of designation. So, what are the reasons that you can take off for yourself or for a family member that relate to victim to violence issues? It can There's something called a qualifying act of violence, is it the definition and term that they use. That would mean anybody who has had bodily injury or death of a family member or this designated person. But it gets much more expansive than that because it also includes people who were subject to brandishing or drawing a firearm against them, even if they weren't actually physically hurt, perceived or actual threats to use force, like a robbery, um, burglary, things of that nature. In high school, my wife worked at McDonald's and they put a gun to her head and robbed her particular McDonald's store. That would certainly qualify on this. She had an emotional injury. It's a qualifying act of violence. So that could be a basis and a reason for it, even if they weren't physically hurt. So that's how the definition of violence works. Now, what are the reasons that you could use to get off for leave? It can be to go get any type of relief, like a temporary restraining order, get an injunction, anything that will help ensure the safety of yourself or a family member, to obtain medical attention, to recover from injuries. That can be emotional harm, so that can include counseling as well as going to urgent care, an emergency room, or a hospital. To seek or get services from a domestic violence shelter, rape crisis center, victim services organizations who help in these settings. Um, to help get counseling, as I mentioned, and make a specific reference to that. It also includes to participate in safety planning, which means if your house, you need to change the locks, you need to get alarm systems, any type of situation like that, change housing, rent a new place, get a shelter, be in a domestic violence shelter, for example, to provide care to family members who might have been hurt, um, to obtain civil or criminal legal services, not only restraining orders, but it could be other actions as well. In theory, that could expand to divorce proceedings, dissolution proceedings, to get that type of help as well. And it's really expansive as far as legal proceedings to attend any hearings, to testify as a witness, to just observe legal proceedings against the person who had caused you harm or tried to cause you harm. It also can include childcare, to as far as arranging for childcare, helping a family member. Maybe your daughter's the one who was adult daughter was the one who was the subject of violence, and somebody needs to watch her kids for a couple of days while she goes to get services. That would fall in that category. Well, assuming that you're 25 or plus employees, if the employee themselves is the victim, the length of this unpaid leave could be the amount they need up to a maximum of 12 weeks. It runs concurrently with FMLA, or the California Family Rights Act version of FMLA, so the state version of that. If it's your family member who's hurt and you're helping with them, then you can limit the employee to up to 10 work days, and 5 of those 10 days can be used to help them relocate. Now, do you really want to spend time tracking, is this time for relocation versus time for something else? In my view, I would just lump those together. And so that way because it's probably a mixed thing. Maybe they're helping with relocation at the same time. Maybe they're helping with the restraining order or something along those lines. So I would focus on 10 days being the thing. But if you really want to focus on, oh, they're moving, so I'll help 5 days worth of that and 5 days of something else, then you can do that if you wish. Just caution to be careful about being overly restrictive on those issues, because this law is going to be read expansively. And the greater the crime or the impact on the family member or the employee, the more they're going to be flexible on those things. So I wouldn't be too hardcore. But you can verify, because people will take advantage, as human nature is. People take advantage. So you can require some forms of verification that I will talk about in just a moment. As part of that 5 to 10 days, it also would run concurrently with FMLA or CFRA as well. As part of this, employees are also allowed, of you as the employer, to request reasonable accommodations for their safety. That can include asking you to move to another location temporarily, or perhaps a modified schedule to get home in time for the kids, or to avoid the person who's maybe have been harming them, changing their work telephone number if they were harassed at work, perhaps permission to carry their phone at work if they were not otherwise allowed to do so, installing locks on any lockers they might have or desks that they might have, or other adjustments that might make them more safe. The way you're supposed to do this is the same way you would discuss a reasonable accommodation for a disability, is that you would engage in an interactive process with them to try to identify any accommodations that they ask for. Again, just like with the ADA, if it's going to cause you, the employer, an undue hardship to accommodate them, then you don't have to provide it. But you need to show a record of meeting with them, of working through the issues with them, and then showing, at least to them and yourself, if you ever have to deal with it, from a legal perspective that they said that they didn't get it, that it was an undue hardship. Now, they have to actually disclose their status as somebody who is a victim of violence before you have to accommodate them. So keep in mind that it has to be an actual issue. Under the ADA, it's a perceived disability. Under this, it's not a perceived victim. They have to actually have to have been a victim of a qualifying act of violence. Just keep that in mind. So what kind of documentation can you ask for? Well, you can ask for a police report if one exists, a court order about like restraining orders, things like that. Documentation from a provider, a doctor, or other licensed medical professional that are treating the person. And that means you too, as providers, may be asked to provide that kind of documentation as well. So keep that in mind if you think it's kind of odd that somebody's coming and asking you about that. It could be because they're seeking leave or seeking some form of accommodation under this new law. So please be willing to listen, consider, and provide notes to the extent that you are counseling or working with somebody who has been a victim of violence or their family member has. Victim services programs in each county, they exist in cities and counties. They have the right to be able to provide letters and explain what's going on and helping a victim in court so they could provide documentation as well. And as I mentioned, while this leave is generally unpaid, the employees can use or allowed, and you're supposed to allow them to use paid sick time or vacation if they want to use it for those things. Keep in mind that this legislation, as well as there's other laws that allow for jury and witness leave for employees to take off unpaid to go serve on a jury and to go testify in court. These are all ones that they can enforce. Now, it used to be that the labor commissioner would generally enforce these rules. That's all been changed to the what's now called the California Civil Rights Department, used to be called the Department of Fair Employment and Housing. That's pretty significant because the labor commissioner is super overwhelmed. So usually they won't get the stuff unless it's regarding a wage and hour issue, where the Fair Employment and Housing Act and the Civil Rights Department are much more aggressive in these enforcements. So you can expect to get letters and calls from the Civil Rights Department if there's a concern that you guys are not following this law. So discrimination and retaliation is prohibited. So under the new law, regardless of what your size is, if you're not working with the victim of domestic violence or one who has a family member, if you're not allowing them to take time off to go deal with restraining orders or appear in court, then you could be sued for discrimination and retaliation. So just keep that in mind. It would be the classic retaliation claims that employers are subject to in settings. So just be sensitive to that and work hard to comply with this. There will be a new notice from the Civil Rights Department as of July 1, 2025. It'll be on their website. It's not out yet. I've looked to make sure we didn't have it available as of today. I will talk to you about some other posters that need to be out now as well. This is the year of the poster. There's 3 new posters that employers will have to add to their already wall of posters that are required in California. This one here should be out by July 1. It will talk about the employee's rights under the law. You will need to either put that poster up or put some other language up that's pretty much identical to it to make sure that employees know that. They may ask us actually to give it out to all the employees. But at the very minimum, it's going to have to be up on your poster wall as well. So know that that's coming here in the very near future. All right, kind of as a companion to that, in the last year or two, I think it's been 2 years now that it's been coming into place, um, employers themselves can apply for restraining orders on behalf of employees when there's a potential for, or when they had workplace violence, they need to be protected in the workplace, or they were subject to potential violence in the workplace. So last year, we could apply on their behalf. This year, that's been expanded so that Unions can now apply on behalf of employees as well to get restraining orders. Still, employers may do so. They're not required to do so, but they may do so. They can also apply on an anonymous basis. There may be employees who are nervous to have their names on a restraining order. We, as an employer, would have the right to go in and help apply on the employee's behalf and get it against an individual or group of individuals who may be harassing an employee. The thing that's really odd about this one, and a surprise to many of us employment lawyers, is that this restraining order opportunity, I'll call it, has been expanded now to harassment, and not just unlawful harassment. For 30 years now, I've been teaching employers that while it's not good to have employees can be a jerk or have your boss be a jerk, it was not illegal to be a jerk. Employee supervisors could be kind of rude, and that's an okay thing. Well, under this law, it authorizes employers to see, and employees as well, to seek a restraining order on behalf of an employee suffering from harassment, which is defined as a knowing and willful course of conduct, which, this is written by lawyers, directed at a person that seriously alarms, annoys, or harasses them. Now, that is strange because it was always based on protected categories. So, sexual harassment, racial harassment, those are the types of harassment that we worried about in the workplace. Well, this allows for a restraining order on any type of harassment. So, how is the phrase seriously alarm, annoy, or harass another person going to be defined by the courts? That is a good question, and nobody really knows the answer to that. So, I know that it would not apply to situations where you're telling an employee to come into work every day on time. If you have an employee who's late a week in a row and you go to them and say, look, you need to get to work. Time is 8:30, 9 o'clock every day, 5 days in a row. Employees often say, well, I feel harassed because my supervisor is making me come to work on time. No, that's not harassment. But there are other things that could be harassment that don't fall into the sexual, racial, gender identity type of issues. So just keep in mind, there's now this new ability of employees to themselves or ask their employer to prevent harassment in the workplace. And it may not be based on those categories. So you're going to have to be a little more careful in listening to what they have to say and parse out what would constitute harassment. So that makes us all a little bit nervous because, when this gets into the hands of plaintiffs' lawyers, this could really get out of hand. So I'm hoping that it doesn't and that it's a more of a narrow definition. We don't want people to be bullied at work, but at the same time, there are sensitive employees who you may just ask them to behave and be nicer and better, and they may feel like that's harassment. So we're going to see how that develops the next year or two. But keep in mind when an employee now comes and says they're being harassed, you can't just limit it to sexual, racial, pregnancy, gender identity, things like that. It can be other things as well that don't fall into the protected categories. It's going to be a slippery slope, and we'll see how that develops. Okay, I'm going to hit now paid family leave and other types of leave. As you all probably know, at the Employment Development Department, along with unemployment, along with disability, over the last few years, employees could also apply for paid family leave. That basically gave them up to 6 weeks of leave to care for a family member who is sick or ill. Often it's used for a spouse when their spouse is pregnant, so they could take off for paid family leave and get some actual compensation. It's not paid by the employer, it's paid by the Employment Development Department as kind of like typically, and it's calculated like unemployment. So, but until this year, you had to be off work for at least 2 weeks before you could get it. And you also had to generally use your vacation before you could receive this paid family leave from the EDD. As of this year, employees can now apply in advance. So the moment that they have a family member with a serious health condition or they want to bond with the minor child and may not fall under the California Family Rights Act. Maybe they haven't worked for a year, or maybe it's a very small employer. Now they will have the right to be able to ask for it in advance and get it almost immediately once the serious health condition happens, or their surgery or something along those lines. So we need to revise our policies where we talk about leave issues to encourage employees to be aware of the paid family leave that they can get through the EDD. Once again, it's good to remind them that you, the employer, are not paying for that paid family leave. It's basically a benefit, as would be unemployment or disability. But they don't have to wait the 2 weeks anymore, and they don't have to use all their vacation. So for the employees, that is actually great. It also, you need to be reminded that it can allow integration with other benefits. For example, in San Francisco, there's a paid parental leave ordinance that gives a little bit more leave to employees. This paid family leave can coordinate with that as well. So just keep that in mind. So kind of a nice benefit for employees that employers really don't have to pay for. Little change of pace. That's not always the case in the past. So now you get to do that. All right, this year, a new limitation about driver's licenses. There's been some discussion at many levels that employees are required to have driver's licenses and available transportation, even though they don't really drive or rarely drive as part of their job. Maybe it's not even in their job description. So job descriptions are becoming increasingly important, and this is one of the reasons why. So under this new bill, you have to um, really have a bona fide reason why the employee needs to have a driver's license and available, reliable transportation. It's got to be an integral part of their job and just not like a once in a blue moon type thing or a just in case type of job description requirement. Um, and in your either job descriptions, your applications, your announcements, if you're, put a job posting on Indeed, if somebody needs to have a driver's license in that, you need to be able to say that, or unless you believe they could probably get the job done by using alternative forms of transportation. Maybe that's BART, maybe that's Uber, Lyft, other ride sharing. Maybe they could do it by walking, carpooling, bicycling. If they can can be able to get the job done without a driver's license, then we should not require it. So it's something you want to take a look at your positions that require driving as an essential function of the job to see if alternative forms of transportation would work just fine. And that could include having their spouses or parents or other members drive them for occasional a need to be somewhere else besides their primary job location. And part of this is not everybody can get a driver's license, but they don't really necessarily need one that often, or if there's other alternatives that work for transportation. So instead of having the knee-jerk reaction of requiring a driver's license for a job, you need to go look through your jobs and your positions available and see if that's really needed and take out that requirement. But you can include in there that they may need to travel on occasion and they need to find their way to reliably get to wherever they need to go. So if that's an alternative form of transportation, that's great, but you can continue to say that. And if they really do need a driver's license and do need to be able to drive, given your location, where you might be, it's an okay thing, but analyze it to establish that it's more than just a once in a while type of obligation. Here's some bonus advice that goes along with that, which is becoming a bigger deal these days. Do most of your job descriptions and positions need a high school diploma or a GED? If so, think about why. What does a high school diploma tell you? It used to be that it tells people that, they can read and write and they can do all those things. But with social promotion these days, and there's not a regularized requirement to what you need to know to get through high school. Um, a condition to require high school diplomas as a job, as part of the job description or duties or requirements may not be necessary. there's a lot of evidence that people don't know that much more having graduated from high school than not having graduated from high school. But yet, a number of people do not make it through high school for whatever reasons. In the South, there was a lawsuit that those who are Black were having much harder times graduating from high school given the requirements and how it worked, and what had elements of discrimination to it. So the equivalent of PG&E was sued to say that they don't really need it, and the courts found in favor of the employees and against the employers that the positions that had high school diploma requirements didn't really need it. For example, I work with the Head Start programs here in both Northern California and Central California. They have food service worker positions that, while they do need to be able to read and follow a recipe, they don't need a high school diploma really in that job. So to have that in there, and we have a lot of Hispanic workers that maybe did not complete high school in Mexico, or it was not a high school equivalent to what they completed there, were being disqualified from food service worker positions as an example. And we could show that it didn't really make a difference, and that was on the discriminatory side. So it's worth it to evaluate your positions to see if somebody really needed a high school diploma. And for example, your medical assistants may be able to get through an MA training program without having a high school diploma. Would they still need that? Would they still have to have a GED? If that becomes an issue in California, I can easily see our local civil rights department saying, as long as they meet the job duties and they can read and they can finish the MA program and do what they need to do, that perhaps a GED or high school diploma is not something they would have absolutely needed. So that could be considered discriminatory under the law. So I would encourage you to evaluate your positions to see if high school diplomas or GEDs are an absolute requirement in that setting. If they can otherwise meet those job duties, then you could avoid a potential claim for discrimination in the future. So hopefully that's helpful. It seems like that's a little bit on the scary side to suggest that that's how it works, but that's how it works. In California, as this year, a new law passed to prohibit captive audience meetings. Now, what are those? The most common ones is you maybe have a union that's looking to unionize your workforce, and they're talking to the employees, and you, as the employer, want to speak to them